Hi everyone. There are two major news that we want to talk about today. Unlike what we do normally, where we're going to talk about success story, we're going to take a lot of questions. Of course, we're willing to take a lot of questions now, but these two news have huge impacts on a lot of people's applications. The first one I want to talk about is the BIA decision that just dropped August 13th, right? People with advanced parole leaving the United States and trying to come back in might have drastic consequences because a precedent that's been here for 14 plus years has now been completely reversed, especially for DACA recipients. Anybody who was on DACA knows that if they get married to a US citizen or their children become US citizen and their parents become US citizen, petition them, they get an advanced parole, they leave the country, they come back in, they adjust status, they get a green card. That path can not longer work anymore. They might also need to require a waiver. Let me explain. In the past, one of the biggest barriers for DACA recipients to be able to adjust status and to get a green card was the fact that they might have entered the country without inspection, right? They were brought here as children, they didn't enter with inspection, and then they were overstayed and they have been here for a long time with unlawful presence. Now, even if they get married to a US citizen, because they were never inspected, they couldn't file for adjustment of status, even though DACA protected their status somewhat. In the past, under the BIA rule since 2012, if you get an advanced parole, you leave the country to visit your family for humanitarian reasons, to work, to study, and you come back into the US and you're paroled back into the US, you're admitted, you're inspected, it doesn't trigger any unlawful presence bar, so later on you file for adjustment of status, or you continue with the adjustment of status, and you can get a green card. We've done that for the past 14 years for so many DACA recipients up till now. With this new rule that's in place, even if you have an advanced parole and you leave the country, that is now considered a departure, and that triggers the 10-year bar. Meaning, if you have over 1 year of unlawful presence in the United States on your record, you leave the US, you come back in, that departure constitutes a 10-year bar, and now you're required to file for a waiver for that 10-year bar. Even if you're married to a US citizen, you might now be forced to file the 601 application. Before you didn't have to, now you have to. Unfortunately, if for some people who are not married to US citizens, maybe both parents are on DACA, for example, or they just don't have green cards, if only your children who are US citizen and only they are petitioning you, then you have to prove the waiver, but children don't qualify. So this new rule that went into effect, this new law that reversed the prior BIA's decision, now basically closed the door on DACA's ability to get green cards, right? One additional door slammed in the face. This rule doesn't apply to the past. So meaning if you've already entered with the advanced parole, you already left and entered, you might still have a chance. Do your best to make the argument in your adjustment of status interview. But if you just received your advanced parole, you haven't left the country yet, that is extremely dangerous now. Now, we think customs officer will still let you in, even though you have an advanced parole, although that is still yet to be tested, right? There's no 100% certain. I know for the past 2 years, 3 years, a lot of people were concerned if it's even worth it to apply for advanced parole in this situation. Will it even be granted? And will customs still let you in? Because they hear horror stories of having received advanced parole, but the customs officer at the border or at the airport don't let them in. But so far, up till now, we've been saying, no, all of our clients have still come in and we were able to apply for the adjustment and we were able to get the green card. We highly encourage people to still apply for adjustment status, but that was the past 2 years. Now, if you are a DACA recipient, if you have unlawful presence that extends over a year, applying for advanced parole, you might still be able to get approved from USCIS, but you might run into trouble at the border. And even if you are successfully entered into the country, when you file for adjustment of status, could it still be denied due to the unlawful presence, due to the 10-year bar being triggered? It is a complete reversal. Nobody saw that coming. Everybody was waiting for a pathway to citizenship for all the DACA recipients. Now one additional door is slammed in their face, and that becomes much more difficult. Now, this doesn't apply just to DACA recipients. This applies to all advanced parole holders, right? And for anybody who doesn't know, advanced parole is you are in the process of applying for a green card, and sometimes it could take months or years before it gets adjudicated. And what if you need to travel? So you pay the extra money to apply for this travel document to authorize you to leave and come back into the country. For some people who are in this process, they came in as a visa waiver, they got married, and then they applied for adjustment of status to try to get the green card. Some people were here as a student and they fell out of status and they got married and they're applying for adjustment of status. Many of these individuals, their I-94, their authorized, their legal stay have expired. And now when they're filing for this adjustment of status, they're on authorized stay because they're married to a US citizen and they're applying for this advanced parole. That advanced parole in the past, when you leave the country and come back in, there was a legal fiction that pretends you never left the US. That was the way it was structured. It was written clearly in the case law. You leave the US, you come back in, it's as if you never left. There is no departure. If you have any unlawful presence in your past, it doesn't trigger. It doesn't happen. You're still as if you're in the US. Customs still lets you in. Now, if you leave the US with the advanced parole, that's considered an official departure. If you have unlawful presence of over 1 year, that triggers the 10-year bar. That becomes an inadmissibility, meaning that becomes a black and white reason why you should not and cannot get a green card. You come back in. At the interview, the officer will deny your case or request you to file a waiver if you qualify. And for a waiver, for an unlawful presence waiver, you need to have a spouse or parents who are green card holders or citizens. If you have children who are citizens or children who are green card holders, that's not good enough. And so this rule effectively will impact millions of people across this country. Happened overnight. It is shocking. It is absolutely shocking. And this needs to be known because a lot of people thought that they could leave because in the past 14 years, everybody's done that, right? You came into the country, you found the love of your life, you got married, you filed for the green card, you're on authorized stay, you have advanced parole, you could leave the country, you could come back in, you go to the interview. If everything looks good, officer believes your marriage, everything gets approved, then you get the green card. You don't have to file an additional waiver application. A 601 waiver application, most people don't know the pain that that entails. That basically forces people to have to write a biography to show that without them in the country, a US citizen or a green card holder will suffer extremely, so that the US government, to protect their own, in a sense, forgives any sort of unlawful presence. The amount of work that is created to do a waiver. We do a lot of waivers. If you check it out, we've done so many over the years, and each one we do, easily 700 pages, 1,000 pages. We usually spend 6 months or longer. We have everybody come together to support. We have pastors, we have psychologists, we have all these people writing affidavits and letters and friends and family and trophies and Instagram posts and all these like family yearbooks to show that this person is good. Unlawful presence is without their ability to control that, and that they are a net positive for America, right? And that without them here, the family would suffer extreme hardship. In the past, if you're married to a US citizen, you don't have to do that waiver. Now, if you have fraud and misrepresentation on your case, if you have criminal history on your case, sure, they might still force you to do a waiver. But if it's merely for unlawful presence, if it's merely because your status was overstayed, right? You came in as a tourist visa, you had a paperwork issue, you couldn't stay, you couldn't leave, you didn't want to leave, now you have unlawful presence of over a year in this country. That could have been easily overlooked. And if you're a DACA recipient, you could have used that advance parole, left the country, came back in, marry a U.S. citizen, and then qualify for the advance parole, and then you could still get the green card, right? But now that changed. We don't know. There's other gray areas. What if you've only have unlawful presence less than 1 year? What if it's 360 days? It doesn't trigger a 10-year bar, but you still have a 3-year bar. What are you going to do, right? And so it's going to be up to the officer's discretion. We also don't know, what if you applied for advance parole a couple months ago and it just got approved, or it got approved, or it's going to get approved tomorrow. If you leave now, will that still trigger? Most conservative immigration attorneys will probably say, yes, it will still trigger because the law went into effect immediately. The case law went into effect immediately. So even if you got the advance parole and you relied on it, you still shouldn't leave. Are there going to be attorneys that's going to try to push the boundary and say, no, you should still go? We still can make the argument that, when you applied for the advance parole, that was the case and you relied on it so you could leave the country, come back in, you could still adjust status. That's definitely risky. We're definitely on the more conservative end. We would not recommend that. Now, if you don't have any unlawful presence issues, you were, unlawful status, and then you filed for adjustment of status while, you were still, your I-94 didn't expire yet, you were still in, lawful status here, and you're on authorized status, you never accrued any unlawful presence in the United States. So this advance parole issue wouldn't trigger any 3-year, 10-year bars. This story doesn't apply to you, but it does apply to millions of people in this country. And it is a reversal that we did not see coming, and it just dropped, and we were just talking with our liaisons. How do we advise the rest of the immigration community? How do we advise the immigration lawyers across the country? These are things that everybody's wrestling with because there's a lot of people who are in this situation, but they have to leave. What do? They're really being forced a choice. Leave the country and do the immigration abroad, but potentially not see the family in the U.S. for 2, 3, 4 years even, if it gets approved. Or stay here and not leave, but now you have to suffer the consequences of not leaving and not being able to do whatever you need to do abroad. This will impact DACA recipients and anybody who entered the country without inspection the most, by far. Everybody else, slight impacts, but still they should know about it. That is the first story we want to cover. I'll take any questions before I head to, we're just going to directly jump into the next story, which is the sham marriage that just got announced, that just got busted in New York. I think about 100 plus people were charged. 11 people were charged, and over 1,000 applications, sham marriages, were linked. And this is said to be one of the largest ever marriage fraud cases in the U.S. history, as in the most number maybe of applications, as well as monetary value attached to it, because it's multiplied by 1,000. Ever since I became an immigration attorney, we've always been hearing this every couple years. Every couple years, there's another big marriage bust, and each one is always bigger than the next. At one time, there was one that was like a Vietnamese community, and there were like hundreds of people who were co-conspiring, and then there were like hundreds of applications that were filed. So that one had the most number of people involved. This one is the most in the sense of amount, right? It's just 11 people. Maybe there were going to be more discovered later on, but 11 people are officially charged, right? But the biggest amount of monetary value and fraud. But when we look into all of these cases, it's always the same. It's always the same idea. Foreign national engages a organization that tries to recruit and find a U.S. citizen, links the two of them, and there's monetary value exchanged, and then there's fake wedding pictures, there's fake applications filed, there's a lot of coaching with the immigration to get past the visa process or get past the citizenship process, USCIS interview, and then to get a green card. And a lot of these, the green cards was already approved, 2-year green card approved, 10-year green card approved. But now that it's discovered that you are linked to this organization and you're part of the scheme, USCIS goes and revokes the green card. And so we're always telling clients and individuals, don't do this. Because even if you are successful, that's terrible because you're going to live in fear for the next 10, 20, 30 years of your life. As long as this organization gets in trouble, you are linked to it, bam, your green card is voided. And all your hard effort in the United States all gets evaporated, right? Things can get frozen, your status gets revoked, and it's going to be nearly impossible to try to get any sort of green card back. And over the past 10 years, we've been seeing how USCIS have ramped up their fraud detection abilities, especially now with AI. And so I'm going to walk everybody through a lot of the things that they do. And hopefully the purpose of this is to let people know it's not easy to fake the government. And even if you can fake them at one point, it's going to be hard to fake them continuously. And even if you are successful in faking them, other people who are not as smart as you might not be able to. And if they get in trouble, you will get in trouble, right? So let's walk through how the government detects fraudulent marriages. And there's so many layers. One of the first things they do is they just directly match the two individuals' background. If it's too far apart and not statistically viable, that becomes something that they already automatically trigger, and this gets triggered instantaneously. So ethnic background between the two individuals, socioeconomic background, right? If the female is significantly wealthier than the male, because statistically that generally doesn't happen, right? If the female went to an Ivy League university in their home country, if their family background is very, very good, have a master's degree, it's unlikely with a good job, good background, is going to marry a male individual with significantly lower socioeconomic status. Not impossible, but immediate red flag. If the US citizen is susceptible to bribe, meaning if their income is lower, if they file for bankruptcy, if their background, just again, socioeconomic background, their upbringing is not the same level, if they are susceptible to a bribe. Now, the craziest ones are if they're homeless, then automatically that's gonna be probably a case for denial. But if you're just slightly better than a homeless individual as a US citizen, you're susceptible to a $5,000, $10,000, $20,000, $30,000 bribe. USCIS will look upon this marriage and relationship and cast doubt on whether or not this is a real relationship or not. These are instantaneous AI adjudication tools that they can immediately use, right? Just using big data. Statistics between the two ethnicities. Is this a common match, right? An Asian woman and a white male. That's fine. That's statistically common, especially through dating apps. But, change things around and you're like, oh, this is under 5 percentile. Is that a concern, right? And so that's the first level. The second thing that they could easily do is now they use time to their advantage. You file an application, it takes months before it gets adjudicated. And sometimes it takes a year before you get the first interview. And even if your 2-year green card is approved, once you file for the 10-year green card, the adjudication time could be as long as 4 years. That is not a coincidence. And that is not because USCIS is just short-staffed. Yes, it is true USCIS is short-staffed. Yes, it is true that they are too busy and all sorts of other excuses. Those are all true. However, delaying the adjudication of 751 cases, meaning delaying the approval and the adjudication of 10-year green card based on marriage, is intentional. It has been intentional. We have heard USCIS officers talk about it, because what better way to test if a marriage is real or not than through time? Time is the biggest equalizer. You can fake something for a weekend. You can fake something for a month. How do you fake something for 5, 6, 7 years? Especially for the female. If the female gets into a fraudulent marriage and they're in their 20s or they're in their 30s, they cannot be in another relationship or they cannot get married again until 5, 6, 7 years later. And right after they get their 10-year green card, they immediately file a divorce. That's going to be suspicious later on. Most females don't want to waste that kind of time, right? Now, and there's another whole scheme of fraudulent marriages in the sense of the female might have already had a prior husband, gotten divorced with their kid, and then they bring their kid over to the US and get married, and now the kid and the mom both get a green card, but when they're secretly still married to the prior spouse, it's just that on paper that divorce is valid, and then they got married, and then after they get divorced, they get remarried, or they don't get married, but the relationship is still there. That is also quite common, and that is also another trigger. You just got divorced not too long ago. You came into the US with your child as a tourist visa. You immediately get married, and then now you're filing for adjustment of status, and now you're going to get 2, 3, 4 green cards out of this? Is this marriage real or not real? Right? There's a lot of investigation that goes into these type of cases. So using time, because at the 751 interview, you've been in a relationship for 5 years now, 6 years now, 8 years now. There's a lot of questions that they can ask. And now the third layer of inspection. When you go in for these interviews, they do Stokes interviews by lottery now. And they say by lottery, but if they are suspicious of the case, they could, just choose to do it. They don't, if your case didn't get selected for the lottery, but they're suspicious of it, of course they can use that technique to separate the two of you. And it's extremely difficult to pass these interviews. Let me explain. If you're doing a fake marriage and we're separating the two of you in separate rooms, and we're asking each person 20 questions, the first question could be, what are the favorite brands that the other person shops at? Okay, maybe you could memorize that and you get lucky. Okay, I know all the favorite brands. You say it, she says it, they match. Okay, what are the brands that the other person hates? Oh, that's a little bit harder now, right? But if it's a real marriage, probably should know. List it out. Okay, when's the last time they had an experience with that brand that they hate and they told you about it? Explain that to me. If you've been married for 8 years, you probably can mention a couple stories. There was this incident. I hate this brand now. I used to love it. I hate this now because of what happened, right? There's a story attached to it, not just a list. Now you match that. It's not the first question that stumps people. It's always the third or fourth question, right? The brand, and then you follow up and follow up. And the thing is, USCIS officers, a lot of them are trained. There's no standard question about how to ask these Stokes interviews. They usually ask, look back on your personal life in the past week, in your marital relationship or your parents' marital relationship, what happened, and take that and make that into a Stokes interview, right? Maybe your parents just had an argument over the food. Maybe it was an argument over in-laws. Maybe it's an argument over private school or public school, right? Education philosophies. If you are truly married with kids, or stepchildren for that matter, you're gonna talk about parenting. Well, talk about some of that in the Stokes interview, right? The basic and the easiest things that you see online, I actually rarely see those being tested. Some do, and usually they use that as the last question. Like, they are already certain your marriage is fraudulent, and then they use these last questions to kind of cement it, right? For example, what's outside your window? Right? Open up the window in the guest room. What do you see outside? How many rooms do you have in your house? 5 rooms? Okay. 4 rooms? 3 rooms? Okay. The restroom? Sure. There's a window there? Yeah. Outside the window, what are the 5 things that you see? If you live in the house together, you know what you see in the window. What do you typically see? Those are like the basic. Those are like the super easy ones, right? Where do you put the nail clipper? Which drawer in the house? Oh, you have multiple nail clippers around the house? All right, tell me, where are they in the house? Which drawers? Most of the time, husband and wife, they put the same nail clipper in the same drawer, right? Unless you really say, no, I have my unique samurai-made nail clipper and the other person has their own. We don't use the same nail. All right, fine. We give up on nail clipper question. What about the common use scissors to cut Amazon boxes? I mean, are you really telling me you don't order from any sort of delivery, right? Show me your Amazon account. Show me both people can log in. Tell me the past 20 things that were purchased, that you purchased, that they purchased, right? So, where's the scissors? In that drawer. What else is in that drawer, right? So if you truly live together and share a life, the basic things you would know. But for fraudulent marriages, there's a lot more things that they test. And they use time, right? And so So in this case, the New York, we see that it was from 2016 to now, 2026, 10 years. That's got to mean some people who filed in 2016, 2017, they got their 2-year green cards, they got their 10-year green cards, they're living their life. But then somebody in 2020, 2021 filed and their case got screwed up. And then now this scheme unraveled, and then they trace it back to which organizer, and this organizer and all the applications that were filed now triggers back to the 2016 cases, right? And it doesn't have to be just in the US, it could be overseas as well. Something I always tell all my clients who are doing these marriage interviews, anything that AI tells you to do, anything that fraudulent marriages can easily do, it's not worth really doing. Sure, do it, you know, I mean, if it's there, right? Joint bank account, you know, health insurance, even life insurance, you pay $7, $20, $15 to buy some term life insurance. Anything that is just mere paperwork, sophisticated criminals and organizations easily does that, right? I mean, they bankroll these cases. They know how to prepare a case, especially with AI. Anything that's easily done is just not that persuasive to a government officer who sees these fake cases day in and day out, and they're trained to identify them. So it's not just a stack of paperwork. Oh, you have utility bills together. Oh, you have a common Costco card. It's the interview. It's the fraud inspection at your home in the middle of the night or early morning or at the office. It's doing the background search. Hey, they see you actually live completely far apart, 50 miles away from each other. Do you actually live together? It's all of these things combined, and how do you persuade the officer, right? And again, these officers are not AI. They use AI to scrub your case, double check everything, understand it very thoroughly, but you're sitting in front of a human being who's might have been married, might have been divorced, might have seen terrible marriages, but ultimately is a trained government officers to inspect and detect fraud. And even if you are smart enough to persuade them and convince them, well, what about the next person that is using the exact same scheme, right? And so we highly, highly discourage anybody to go through this process because we have seen horrible, horrible stories. And we just see it again. And a lot of people think it's so easy. My relationship, of course, is real. My feelings are real. It's not about your feelings to a USCIS officer, to a consular officer. To them, they are trying to catch criminals. To them, you're not just one case. They're concerned that if you are connected with a broader range of cases, and the consequence of marriage fraud is extremely devastating. It's a death nail to your case, of which almost there's no waiver. So anybody who's trying to sell fake marriages, anybody, and you're hearing that like, oh, this is my only option now, I'm out of status, it's the easiest way out, be extremely wary of that. Now, I really want to mention something. It's not illegal to get married for a green card. It's illegal only in this situation if you get married only for a green card, right? If the person is tall, rich, handsome, and a US citizen and you get a green card out of it, wonderful, good for you. And good moral character and, you know, all the good things. But if they're hideous, if they are immoral, if they are repulsive to the human soul and eye and ear and smell, and you're only marrying them because of a potential green card, that is marriage fraud. And so the reason I'm saying that is instead of going through a fake marriage scheme, you know, just try dating more, right? You know, just like, don't go through these schemes because these schemes are so bad and the consequences, and we've seen, is so far reaching. But, you know, give another US citizen a shot, you know what I'm saying? Like, there are many people who are good quality, and if you give them a shot and it turns out you get married, you get a green card, the process is long, you try it out, and it might work out, and you might fall in love with them, and you might have a kid, and things might work out, and that is fine. But don't go through one of these schemes, right? And don't try to orchestrate it yourself either, and trying to create these conditions like, okay, well, nobody's gonna know, we'll live in the same address, but you live in one room, I live in one room, we live our own lives, right? We're just friends, but we're helping each other out. Like, the government sees through all of that pretty easily, right? Online, they scrub the social media profile, and it's like, oh, you guys are young, I see both people's Instagrams, and you guys are not in any of them, or you guys are barely in any of them, right? And at the interview, they just say, hey, let me look at your phones. Let me see your Instagram shares. You don't share anything to each other. You don't joke around with each other. What kind of relationship is this, right? All you guys talk about is finance, and all you guys talk about is like who's paying the bills, and just commercial transaction. It just looks like a commercial transaction. You guys just look like you guys are friends. It doesn't look like you guys are lovers, right? And so these are the things to think through, to prepare for. And anybody who's in the process, right? The saddest part of all this, 4 categories. Fake marriages who look fake. That's not sad. That's just dumb, okay? Fake marriages that look real, okay? That's what USCIS is trying to detect. Not that much sympathy for that. Real marriages that look real, great. I'm sure the case will get approved. I have confidence in it. You have a lot of good documents. If the officer inspects, unless you have a bad luck and the system is broken, then maybe you get some trouble. But we truly believe a good marriage that's true, that have a lot of documents, and maybe you just didn't prepare well enough, but you should have a second chance, right? At the interview or a refile, you should be able to get through. The saddest consequence are the real marriages that don't have enough documents and they look fake. And these are the people, so many good, well-intentioned young people specifically, who file cases, but USCIS can't see enough, and they get denied and they get screwed over because of these sham marriages. And so anybody who's filing these applications, obviously AI is going to give you a lot of guidance on how to prepare, but the key thing that I'm always telling people during the consultations is, if it's easy to fake, fraudsters would do it. In front of the officer, 10 cases, they suspect 9 of them are fraudulent. You have to go way above and beyond. And it might turn out that the interview is super easy and it's a breeze, but you don't want to take that chance where your case suddenly gets put in the fraud category, and now it's a 4-year-long ordeal, and you're always in limbo, and you're terrified. So prepare your case well. It's not rocket science. It's just proving your relationship is real. But it's not like anything else in American civic life where you just bring 2 or 3 utility bills, like getting a driver's license, getting a library card. It's getting a green card. And there's so many, there's not that many people trying to fake to get a library card, but plenty of people, and these schemes prove it, that they're trying to defraud the US government. And so be very careful and prepare your case well. Family and friends, they are good testimonies, social media, use everything that you can to your advantage, right? Your work, your religious organization, your school, your childhood friends, your current friends, your online profile, anything you can to prove your case. Because if you lose your status, you lose your ability to be in the country. That might mean you lose your career, your future, your spouse, everything. So take it extremely seriously.
Yeah, a few two related questions are how to prove a 30-year age gap,
Okay.
and how to consider appeal or refile.
Okay, let's do the 30-year age gap first. First of all, 30-year age gap is going to be a red flag no matter what. But if it's a 30-year age gap in which the woman is a lot older, it's a double red flag, right? Just putting it out there. 5 years woman older than the male, depending on what age bracket you are, sometimes already triggers it. Now, 30-year age gap, that might not definitely and make the case like extremely fraudulent, right? It's just a red flag, but explain that. Now, how to prove it? It's the same as any other relationship, right? How do you prove, homosexual relationship is a real marriage? It's just like a real marriage, just like everything else, right? So still look into the finances. If it's 30 age gap, will and trust might be extremely important. Now, anybody can just do a wills and trust on LegalZoom and spend a couple $100 and a paper comes out and you sign and notarize it. It has no real persuasive power. But if it's an irrevocable trust, oh, that's a different story. Now you paid real money and with a real entity like a company that named the real beneficiary that you can't take back. That might become something worth considering and doing, an irrevocable trust. And if the irrevocable trust includes an LLC, a company in which there's substantial ownership, and in which the LLC and the company and all the other members were notified and understand that if the main person passes away, the trustee passes away, that this foreigner is inheriting everything, that is also a really solid proof, right? So again, that ties to finances. So, use your unique situation in your life stage to talk about things that only pertain to you guys. Some 20-year-olds with, without a cent to their name, if they did a wills and trust, that doesn't really mean that much. But if you're significantly older, you have all these things. If you have a 30-year age gap, presumably you lived an entire life. You have lots of friends and family, and you might have gone through prior divorces. You might have other kids. You have neighbors. You have, all these people that have been in part of your life. Have you introduced the other person to all of them? And if you haven't, why are you keeping a secret? I understand it might be extremely inconvenient, but that will significantly help your case because it shows that you really care about this other individual for the sake of their at least green card, for the sake of this marriage, for the sake to prove that marriage is real. You've let every single person you know, right? And everybody can write an affidavit and everybody can testify and you have all these dinners planned. So in your life stage, think about what's to your advantage and what you can use. I think that is far more convincing than a joint utility bill to the same address. Okay, and then you mentioned the other thing, right? What was it?
Appeal or refile?
Appeal or refile. We've done both. When you appeal, whether it's motion to reopen, motion to reconsider, or you literally go through AAO, or you go to federal court, the thing you need to know is you cannot really provide new evidence. And if you do, you really have to provide a persuasive argument why you didn't provide it earlier. So let's assume you cannot provide new evidence, or whatever you provide they don't recognize. Did you do enough? Did you already go above and beyond? Because if you only went 70%, if you only went 60%, you go through this whole appeal, it might come back and say that just wasn't enough. You should have provided more. And then now you have to redo it again. Now, if it's a case where you've already given 100%, you cannot give any more, it's a 100% racial discrimination against you. It's just a prejudice. It's just this evil officer that's out to get you no matter what. If that's your situation, well, let's get this officer fired, right? Let's appeal it to the supervisor. Let's bring it to the court. Let's put this on their record that they are this racist or they are this evil. So that's the easy answer. Did you already provide everything? And if you did, do you really want to attack that officer? Because sometimes if you provided everything, it might just be simpler just to refile again. And I know a lot of clients who choose to do that. I remember there was a client that chose to do an appeal against my advice, got denied, refiled, and immediately got approved. And they were convinced it's because they appealed it and they really showed that, hey, I mean business, don't mess with me. And then they got approved. So maybe that's the third option, appeal and then refile, right? But again, you're spending double the money on filing fees. Yeah, so, I mean, every case is different, right? I don't want to say everybody should appeal, everybody should refile. I would say in the past, most people would recommend refiling improve the case. And I think that is probably still true in this day and age. But given the situation with the notice of intent to appears and ICE and all this stuff, there is a new segment of population where maybe appealing might make more sense because you want to preserve your original filing.
I-134 financial support to prove relationship is real?
I-134 proving financial relationship is real? Is that the question?
Yeah.
Okay. That is to try to sponsor somebody, and you're trying to prove that your relationship and you have enough to support them. If you're asking what documents are usually required or what consular officers really want to see, pictures, statement, typically enough. We haven't seen a lot of pushback on this. The most important thing that they're looking for is, do you have enough funds, right? And so they even take the I-134 with a grain of salt. So it's a nice to have. It's not ideal. It's best to have the parents as well as the children directly have enough funds to do everything that they need to do, whether it's a student visa or any sort of other visa. But if you're bringing in another co-sponsor, doing it helps the case. But you can't be a stranger, right? And so why are you giving it, out of the goodness of your heart, right? How are you supporting them? And sometimes it doesn't have to be all money. You're providing them lodging, you're providing them transportation, you're providing them with your connections to be able to help navigate through American civic life. These are all nice supports that you can add into your letter, right? And so when you write a really nice letter to the officer, they might enjoy reading it, and that might move them to approve the case even more than the I-134 form and how much bank account you have, because that's, to them, it's just a number.
Can I contact or should I contact my senator?
Should you contact your senator? When you contact a senator or a congressman, they will make you fill out a form, and then on your behalf, they will contact USCIS to check if this case is, in normal processing. And if it's far beyond processing, USCIS will respond and then take a look at your case. That is the main use for when you contact senators. If it's all within normal processing, USCIS just says it's within normal processing, and the senator says, oh, everything is normal, right? So it really depends on if your case is really outrageously beyond processing time.
My lawyer told me everything is approved for my wife's green card, but it's on hold like a lot of cases.
You really want to find out what they're talking about, because it could be your I-130 approved, or it could be your 45 that's approved, it could be 765 approved or I-131 approved. Find out exactly what has been approved, what is waiting, what's the holdup, and just find out more details and get your case number and check it online. I just did a consultation about an hour ago where they were completely defrauded. They were provided fake R1 approval notices, provided fake 360 approval notices. They were told that their case is approved and they're just waiting. But the case number that they use when they check it on, it says approved, but it's not their name, right? They don't see the name. And when they check with USCIS, the FOIA records doesn't have anything. So they suspect they've been defrauded. So now, if you're hiring a law office, if you're working with a lawyer, that would be extremely, extremely rare. This person probably, contacted an agency and defrauded a lot of other people as well. But in your situation, you could get your entire file and just find out more details.
I filed for VAWA and I got my receipt. Can I go for all the benefits that was offered?
Can you get all the benefits that VAWA offers? I would want to find out what benefits you're looking for. VAWA is very specially protected in the sense of you have more leeway with the kind of public benefits you're able to receive because you're probably an abused and a victim and the government wants to take care of you. However, it is a green card application. Public charge may apply to you based on the officer's discretion. Maybe, maybe not, right? And even if it doesn't, in the back of their mind, they might be thinking it. And so you're still up for review. And so it depends on what kind of benefits you're really looking for. If you're talking about you apply for VAWA, you get a work permit, and now you want to work and pay taxes, go for it.
My brother has DACA and son is 21 in October. Son only makes 25,000. Is it enough for 864A or better to have a joint sponsor?
Joint sponsor. Yeah.
And then I'm on B1 entry. Is it possible to adjust status after marriage if sponsor citizen has medical issues?
I want to say it's not impossible. It makes it extremely more difficult for a lot of reasons. And your case, you mentioned you're here on a tourist, you're getting married, you're filing for adjustment of status. So this year's May 21st, 22nd memo clearly applies to you. So you have to make the argument why you are choosing to stay in the US instead of leaving. The medical issue might help you in that regard, but if they have medical issues and they cannot leave the country, or the spouse cannot work, then public charge might be a bigger issue, right? And so there's a lot of things that kind of, all bundled together, and you really want to be able to prepare your case well. I don't want to say it's possible though, right? It's still, legally it's possible, but you just need to prepare the case well and convince the officer that the marriage is real, so the I-130 could get approved. You're not a public charge, and that the officer, in their discretion, should allow you to file the adjustment of status as opposed to forcing you to go back home, right?
My U.S. citizen husband divorced me, and 2 months later, I married another U.S. citizen. Is that an issue?
It is T that the officer might want to talk with their fellow officers about. But if you're saying, is that a direct issue that will cause the case to be denied? Not necessarily, right? Not necessarily, but you do want to explain. Well, we've been separated for a long time already. This just wasn't working out. We already started dating with somebody else. They are also U.S. citizen. Because some marriages and divorce take a long time. I forgot, there was recently there was a couple other celebrities that now they're officially separated, but they've already been separated for like 2.5 years. So once the divorce ends and you immediately get remarried, it depends on the context of the relationship, right?
My husband does Uber and Lyft. We're about to apply for my I-485. Do we need a sponsor?
Well, it depends on how much he makes on Uber and Lyft, how much assets he has as well. I know some people who are extremely wealthy and they still do Uber and Lyft, right? They do it for fun, they like driving, they like meeting people, they like practicing English. There's lots of reasons to do Uber and Lyft. They want additional things to write off. They want to get out of the house because they can't stand being in the house and being yelled at all the time. Whatever. Every marriage and family is different. I know some, executives who do Uber and Lyft. That's a different problem in itself, but it depends on the holistic circumstance. What's their education? What are their assets? Are they between jobs? Are they trying to find a different career? Are they, while they're doing Uber and Lyft, are they, listening to a whole bunch of podcasts and improving themselves, and they're trying to AI code and vibe code something while doing, what are they doing? And how do you demonstrate that the two of you and your family have sufficient funds that you will not be a public charge? What is your education? What is your health? What is their health? What is the family support? But when in doubt, get a joint sponsor, right? Like, if everything is low because of the new public charge rule, having a joint sponsor can only help your case.
Can receiving DACA subsidy affect N-400 application?
Can receiving DACA subsidy or
Is it ACA subsidy?
Oh, can receiving ACA subsidy affect citizenship? Is that?
Yeah, N-400.
N-400. Yes, because I remember reading it in the August 2025 public charge memo that affected the naturalization. Now, I don't know the September one, the one that's just about to be released, but the September one, public charge applies to green cards. The August one from last year applies to citizenship. There is inevitably going to be an overlap, but the August one from 2025 is under the good moral character section. And under the good moral character section, they look at all the different things where they determine if you are a good moral character. One of them is, are you able to hold a job, file tax returns, etc. And part of that is looking into your finances. So if you use a lot of benefits when you shouldn't be using those benefits, they may interpret that as you don't meet the good moral character test and therefore deny your case. Just like if there's a tax lien, they could deny your case. So your question, does receiving benefits affect my naturalization? The answer is yes, it does affect it. Are you able to overcome it? Are you able to persuade you still have good moral character? Even though you receive a couple benefits, you might want to use a lot of the arguments that's in the September public charge memo on adjustment of status, because that's more detailed. I did use it, but I only used it temporarily. It was not a cash assistant. It was, and I had all these other things going for me. And my future is really bright. And look at all the contributions I made. Look at all the taxes I paid, right? So use different things to kind of offset that, but ultimately proving that I am equal, if not better, than most Americans, without saying it so blatantly.
My wife got miscarriage. Can we add this document?
I'll repeat what I said earlier. Your question is, my wife had a miscarriage. Can I use this, add it to the document, in the sense of, can I use this to prove my marriage is real, right? Miscarriage is extremely heartbreaking event for a lot of people. Some people start a GoFundMe page because of how devastating this is. I have several family members, I have friends that have gone through this process multiple times. I'm sure the officer have as well. With that being said, a miscarriage on paper is not that hard to create, especially when a lot of the medical documents are sealed and not released to the government. Meaning, especially, last year we saw a case where the woman was freaking pregnant and the officer still did not believe the marriage was real. And you're like, WTF. And from the officer's perspective, right, just to, be fair, the birth certificate doesn't list the father yet. Is your baby somebody else's baby, right? Like, how do I know? You have a big belly. I'm not going to go touch it right now, right? So if everything else looks fake, you just have a big belly, it's not conclusive. Anyways, that story obviously it just shines the light on it's a totality of the circumstance. So my main point is, if it's just a miscarriage and all you are doing is providing a document and there's no surrounding story that's tied to that and in your relationship, do not bank on that being sufficient to win your case alone. If you already have a strong case, it's a real miscarriage, add it in, it will only help you. But be prepared to explain and talk about it. When did you find out? Where did you go? Where were you when you told the other person that there's a miscarriage? They might separate the two of you and ask you these 20 questions about the miscarriage. And if your answers completely don't line up, it actually created a reason for them to deny you, right? So again, it's a very emotional situation. It is a great evidence if it's well documented and you have a lot of things to talk about. But I can imagine a lot of criminal organizations create that to try to persuade an officer that is less suspicious.
Yeah, just to add to the previous question, the husband's interview is in Dominican Republic.
Oh, okay.
So he doesn't have a job for a year.
I see.
And then he's petitioning for citizenship.
He's petitioning for citizenship if he's out of the country? I mean, most of the people who are overseas are trying to get a green card. But now if he already had a green card and he just left the U.S. for a long time, his bigger problem is physical presence. Because if you have a lot of physical presence, he cannot get a citizenship, right? So now if it's a green card issue, he doesn't have a job, it is a public charge issue, right? Then you have to have sufficient funds in the United States to sponsor him.
Okay, we have 2 minutes. Some processing timing questions.
Sure.
751 pending for 32 months and 400 pending for 16 months. Is this normal?
N400 pending for over 12 months is long. We see usually 8 months to 12 months, but if it's more than that, it's definitely long. 751, 48 months is their average, so that's not itself long. But because you have both applications pending, I think you're getting to the point where you can consider doing a mandamus. You can definitely maybe wait a few more months and then do a congressional inquiry to try to push them a little bit. But it should just be around the corner. But if after 6 months they still don't do it and you're just absolutely tired of them waiting, yeah, you could do a mandamus action to push them. But still safer to wait the full 48 months of the 751 waiver or 751.
How long does it take for employment authorization and interview for marriage-based green card application?
In California, it's different than everywhere else. I remember I was on a panel with other AILA immigration lawyers. They were saying Florida was as fast as like 4 months to 6 months, 7 months. So a lot of people don't even apply for advanced parole or work permit because the green cards come so fast. In California, we routinely see 8 months or higher. There are some, fast cases between 4 to 6 months, but those are very rare. We do see most cases are all above 8 months.
So it could be a citizenship question, but it's not clear. So he's out of the U.S. from July 2024 to January 2025 due to high-risk pregnancy, but still paying rent and bill. Doctors are overseas, but in the U.S. they wrote a note. Does that work for citizenship?
I see. So there's 3 physical presence tests if you want to apply for citizenship. One of the tests is in the past 5 years or 3 years, have you been in the U.S. for half the time? Simple math problem, add up the days. The second test is, did any of your trips exceed 6 months? In this case, it does exceed 6 months. So you're going to get a really challenging case where they're going to challenge you. Can you prove that U.S. is your home and you did not intend to abandon it while you were abroad? And the reason for did you leave abroad was temporary in nature. And the third physical present test is, on a whole, good moral character. When they look upon you, your education, your history, your work, and everything, does it look like you are a good moral character person that you want to be in the U.S.? So, all things considered, you have to prepare a good case and convince the officer. Being pregnant overseas, cannot come back, that's one major factor. But can you explain everything else? Where's the rest of your family? Is everybody else here in the U.S. and you're just there? And was it an accident that you were stuck there? And you really couldn't leave, right? Where's the spouse? Where's your work? Where's your retirement? Right? If everything is overseas and it's just cheaper overseas and there's a clear reason why you chose to be overseas as opposed to here, that may make the officer feel like, oh, you're less American, you want to be abroad, right? And so the third physical presence test is really the new thing that kind of changed this whole game, right? In the past, you just focus on those 2, but now they take a comprehensive look. So if your question is, does it affect the citizenship? Absolutely. You need to do a really good job. It's not impossible to win it, but, it's definitely challenging.
Yeah, that's all.
Okay. Thank you, guys. We won't be here next week. And we will be posting this on our platforms later on. I know it's extremely concerning for a lot of people. I wish everybody well, and I'll see you guys in about 2 weeks. Okay, bye.